Ever been downright copied and thought the cost of a lawsuit outweighed any possible benefit to you? Listen up and think again thanks to the CASE Act. In this video, I'm going to explain how the CASE Act can bring justice to creators online. I'm Maria Spear-Allis, lawyer for content creators and online brands, and this is the Spear IP Show. So what is the CASE Act? It is the Copyright Alternative and Small Claims Enforcement Act. We'll just call it the CASE Act, okay? It came out of the December 2020 stimulus bill. And if you think that's really weird, you are absolutely right. The CASE Act created the Copyright Claims Board, or CCB, in the United States Copyright Office to hear these types of cases. What types of cases? I'm going to tell you. There are 3 types of cases that can be brought in front of the CCB. 1 is an infringement action brought by a creator if someone copies them. Justice for creators! 2 is a DEC action, otherwise known as Declaratory Judgment. And this is big. This means that someone on the receiving end of a cease and desist letter can file with the CCB instead of having to file in federal court to say, hey CCB, I want you to declare that I am not infringing per this cease and desist letter. And then the 3rd type of action is a challenge to a takedown notice. I've talked about these before as kind of one of the options when you've been copied, but it's that takedown notice that you can submit to Instagram or YouTube or wherever when someone posts something that is infringing on their platform. And so the type of action that can be brought here is a challenge to one of those takedown notices. Without the CCB, without the CASE Act, all of these types of actions or lawsuits have to be brought in federal court, which is expensive. And this is a big block to a lot of the people who have these types of cases. Visual artists, photographers, online creators, bloggers, those types of creatives. Notice, this is not just about bringing justice to creators who've been copied. It's also about those who are on the receiving end of BS claims too. So, important thing to remember, number 1, this is not a requirement. You can of course file a lawsuit in federal court instead of filing with the CCB. Important thing to remember, number 2, if you file, the accused, really called the defendant, has 60 days to opt out. They can opt out of the CCB entirely. There are incentives not to opt out. The CASE Act limits the amount of damages or money that you can get in a CCB type of proceeding, like those statutory damages that you've heard me talk about, up to $150,000 for infringement, while the CASE Act whittles that down to $15,000. So if you've done wrong, it's better for you to stay in front of the CCB than it would be to go to federal court where you could be paying a lot more. When does this beautiful thing go into effect? Well, according to the law, the CCB must go live by summer of 2022, but it could go live as early as December 2021. So again, how does the CASE Act mean justice for online creatives? Justice if you're copied and can't afford a full-blown lawsuit in federal court. Justice if you're wrongly accused of copying and you don't want to file a declaratory judgment or DEC action in federal court. And 3, justice if you're on the receiving end of a nonsensical or misrepresentational copyright takedown notice. So I hope that helps you to better understand the CASE Act and how it might impact you and bring justice to creators online. And I'll see you next time. Head to spear-ip.com/quiz to take my quiz on identifying the #1 legal blind spot that is secretly killing your business. Not only will you learn about that legal blind spot, but I'm going to tell you how to fix it all by yourself. Again, that's spear-ip.com/quiz.